Court does call the case of Arbor One versus Tatiana Tedder.
Cheryl Welkoff on behalf of the plaintiff.
She's here, I know, because she's
Yes.
always here. All right. Miss Tedder, good morning.
Good morning.
All right. How much is owing on this one?
Total including court costs $2,956.10.
Miss Tedder, how are you going to get that paid?
Well, I'm working with DHS and I'm working with another place. But the thing is, Your Honor, I have a tax return check that would have been in the mail if my mailbox door would have been fixed. I've been without a mailbox door for over 60 something days, and so all my mail is getting returned back to the place, back to the company. So I'm not getting my mail on time. I just got my court summons on last Thursday in the mail, and I've been seen to coming through the mail weeks ago. So I'm having a hard time with that situation.
Your Honor, just for clarification.
Yes.
How are you getting, because that's not atypical that you received on Thursday. Are you saying yesterday you received the papers for today?
No, I'm not saying yesterday. I'm saying last Thursday.
Okay. I mean, that doesn't surprise me, but how are you?
I've been seeing I don't know if you know what the USPS mail system thing is on your phone, but you can see your mail coming to your mailbox before it gets there. And I see my mail coming, but I won't get it because I haven't had a mailbox door for over 60 something days. So they're sending my mail back to the
What do you mean?
Your Honor, were you saying something? I couldn't hear you.
No, I was wondering, she says
okay.
She doesn't have a mailbox door. I don't know what that means.
So we have mail. I just moved in here February. When I moved in here, I haven't had a mailbox door for 60 something days. They put the mailbox door on. I had to wait an extra 3 weeks after that to get a key. Now my mail is still not coming like it's supposed to come. So all my mail that I've been getting, I haven't been getting my mail from DHS or anywhere. So, that's putting me in a hard spot to pay anything when all my stuff is coming through the mail is being resent back to the place because they don't want to come and fix the mailbox. Everything is on their time. And then go ahead.
I just want to understand, you're saying on one hand that you don't have a mailbox door, but then you were saying that they fixed the mailbox door, and then you're saying You're not getting mail, but you're saying you received this in the mail. So I'm just trying to understand so I can help you.
Okay, so ma'am, when they send you the mail, it takes long to get the mail. Then I have to wait for them to send the mail back to the company, and then the company resends the mail again.
Okay, but hold on, Miss Tedder. I think what's being asked is, do you have a mailbox?
Yes, I do currently. Now I do have a mailbox door, but I have to wait for them to resend the mail over and over again to even get the mail. I would have been had my rent paid if I would have had the mailbox door, but with them sending my mail back every time it comes, I can't get the mail.
All right. So, ma'am, you're indicating that there was a tax check you were supposed to receive?
Yes, and my bridge card, I can't get that.
Well, hold on.
Hardly anything.
Hold on, ma'am. And you were going to use the tax check to pay the rent?
Correct, because I'm currently just stopped working. Because I'm 8 months pregnant, so I'm just stopped working.
All right. Okay, ma'am, here's what you're going to have to do. You're saying you have proof that it was delivered to your mailbox?
I have
via
proof
the
that a lot
UPS.
of mail been. Yes.
But the one I want to see is that the tax check came to your mailbox. So you should be able to print that email and send it to the court.
It's not an email.
Be a nice picture of that check.
It's not a picture of the check. It's just a picture with Stan from the Treasury Department. It's like a real picture of the mail.
No, I know. I know what it is. I'll see the envelope.
Okay, yeah, and then I had something else as well. I don't know if it's like Arbor One on here as well.
Pardon?
I said it's Arbor One on here as well.
What do you mean? Are they on here?
Like, because I've been having issues. I've been having issues with them coming to fix my property, period. I have black mold growing under my sink. I have a sick child in here who has a heart condition already. My kitchen floor is so wet from every time I turn my dishwasher on, turn my kitchen water on.
Miss Tedder, here's what we're going to do. Miss Tedder, you need to submit to the court. I want to see a copy of the email that shows that your tax check came or either wasn't delivered, but I want to see proof that it was headed to your mailbox.
Okay.
And then you're going to need to file an answer if you're claiming that there are repairs that aren't done. Did you submit a request for repairs?
I have submitted so many requests. I have went to the office so many different times.
All right, here's what you're going to have to do. You're going to have to put all of that in writing. You're going to have to send the court a copy of the repairs that you're requesting, as well as a copy to the attorney for Arbor One.
Okay.
Miss
I need that in
Tedler,
writing. I need that in writing to the court by next Thursday.
Okay. And like I said, I am working with DHS and stuff too, because now I don't know how long it's going to take for them to reissue the check and stuff. So I did call so I can at least have something going on.
What check? DHS issued? You say they issued you a check?
No, I'm saying I'm working with them because I don't know when I will receive the check again through the mail.
Okay, I need proof that you're working with DHS also.
Okay.
So you're going to need to get all of that to the court and a copy to counsel. If I don't get this stuff, then I'm going to grant them a judgment. Understood?
Yeah, how will I send it in?
Pardon?
How do I send it in?
It can be brought to the court anytime.
Okay.
We're open every day from 8 till 4.
Okay.
Turn this out to the 17th, 2024. Okay? Thank you.
Okay. Go!
Hand me my screen box. Now go freak.
Arbor One versus Tatiana Tedder.
Cheryl Walkoff on behalf of the plaintiff.
Ms. Tedder?
Okay, I'm here.
Okay. All right. Where are we on this case?
Well, Your Honor, my notes indicate that the defendant was required to file an answer and proof of her claims by May 16th. I did not receive anything. I don't know if the court did.
I'm sorry, I'm having a hard time hearing. Could you repeat what you said?
I indicated that the last hearing, the court had ordered that you file an answer and any supporting evidence to the court and myself by the 16th of May. And that I did not receive anything.
Right. So I was unable to get in my emails and find the emails or whatever for the thing, but I went down to the office multiple times to talk to the people in the office, and they tell me you guys will call and nobody never calls. So I'm just a little confused myself. I've been
ma'am, hold on, ma'am. You told me the last time that your taxes got held up.
Yes, sir.
Okay.
I have not been able to
hold
get my mailbox
hold on. You said it was because of a mailbox situation.
Correct.
And it went someplace else. I told you because you were. I'm not going to try to talk over you.
Okay, sir, you don't have to try to talk over me. I apologize, but this is very frustrating when I've been doing everything I'm supposed to do on my behalf and they're not doing what they're supposed to do on their behalf. So I'm frustrated too.
You told me that the tax check that you had got sent back.
Correct, twice.
I told you because you said that you had the United States Postal Service email on your phone.
Correct.
That you get. And I told you I needed a copy of that email to the court to show that had happened.
Right. I'm unable to pull that up on my phone.
I don't have that. What?
And I'm unable to pull it up on my phone, sir. It says my Gmail is out of storage. It only lets me go back so far to my mail because I can't pay for anything because I don't have any money. This is not the only bill I'm held up on. I've been saying stuff for over the last 70, 80 days. And it's like nobody down in the office hears you. But then you want a payment. Like, it's ridiculous.
Ma'am, I heard you when you told me at the last hearing what you said. You told me you had proof of that tax check coming through. I don't even know how much it was. I was going to give a benefit of the doubt to you because of what was the mailbox issue, that if you showed me that it came, and then go by the rest of your story that you couldn't get to it and it got sent back or held someplace, then I could do something. But I needed proof that had come through. You told me you had the email. I don't have a copy of that.
Okay, right, and I understand that. I am sitting here on bed rest. I can barely even get out the house to do anything. I'm going into labor any day. I don't understand. I'm calling down here and saying stuff to them. I can't make a payment if I'm not receiving my mail. And it's like, just forget that I have mail coming in and that my money is in the mailbox. They just want their money, but nobody is doing anything so I can get my mail. This is ridiculous.
Your Honor, the last hearing, my recollection is she indicated she was now getting her mail.
Right, ma'am. I am now getting the mail, but it takes weeks for you to get the mail. They have to send it out, then they send it back. Then I'm waiting for you to send it out again. They sent it out again. They sent it back, and I'm waiting again. Like, I just don't quite understand. But it's okay for you guys to inconvenience me for 70, 80 days. But it's not okay for me to inconvenience you. And it's not even me inconveniencing you if my stuff would have been fixed when I first moved in here, when I paid my money to come here, it wouldn't even be this.
Are you done now? Because I'm going to tell you.
Yeah, I am done, sir, but I'm frustrated because I'm steady contacting them and they're not sending me back.
But you don't overtalk me. I will hear anything anybody has to say. And I listened to you the last time. And what I told you was, you told me that the mail was going back and forth. I said, okay, fine. You specifically indicated there was a tax check that had gone back. I said, fine. Send me a copy from the UPS delivery, from the United States Postal Service delivery message that you get. Send me a copy. And then we could work on timing, because if you couldn't get into your mailbox, you can't get into your mailbox. That's what I asked for, proof that came there, that you couldn't get it based upon your story, and then we could work something out. But I don't have anything. I think I was very clear as to what I wanted.
And I'm unable to get, I said I'm unable to get anything either because I can't even pay for my storage space on my phone so I can even get to my emails. Like, this is really ridiculous. I'm literally about to go on labor any day. I can't just get up and go work. I had everything planned out. If my stuff would have been working from the day I moved in, it wouldn't even be this issue.
Ma'am, I needed proof that the tax check came in and that you didn't get it.
Sir, and I don't know how to get you proof. I've got on my laptop, I've got on my phone. I'm trying to get it. There's no way for me to get it. I've tried to call them and see maybe if they can send me some type of email stating that they sent it. They said no. So I don't know what else to do. I called DHS. I've called somewhere else to help, which I shouldn't even have to do all this when my stuff came through the mail, and I should have had access to it the first time it came.
Ma'am, maybe all of that's true, but I gave you an opportunity to just give me proof that the tax check came in, and I have nothing.
Sir, I can't give you something that I'm unable to get myself either. I can't give you proof of something that I'm having trouble with pulling up myself. I have 2 other children here. I don't want to get put out. Like, come on now, this is ridiculous. I paid my money to move in here and I can't even get my mail.
Ma'am, I don't have much of a choice here, though.
Okay, well, you just do what you feel like you have to do. End of story. Like, I'm not about to keep going back and forth with you.
What's the claim, Miss? Hey, I'm done. What's the claim? I've tried. Go ahead. What's the claim in this case?
Your Honor, rent to retain $2,781, cost $175.10, total redemption figure $2,956.
Court finds no tribal issue. Judgment to the plaintiff for possession. Redemption amount is in the amount requested. Writ to issue 10 days. Case of Alec Jerome versus Eric Cassidy. To be Eric Cassidy and Paula Cassidy. Go ahead.
Donna Tope, appearing on behalf of Caroline Jerome, who is watching by Zoom. I recognize Caroline.
Okay.
And Alec Jerome. They are the landlords in this.
Got it. All right.
Your Honor, Francine over appearing with Eric Cassidy. Ms. Cassidy, Paula is not well. She's been undergoing chemotherapy, and so she won't be present.
All right. Very good. All right. So where are we now in this case?
So appeared before you, and I have on the results of that hearing. I got their counter complaint, et cetera, and I have filed a complaint bringing the non-payment amount that we are requesting for judgment up to date. And it was.
Hold on a second.
I filed a complaint on Tuesday, and we've been given a case number, but I would.
Hold on a second.
Okay.
You filed a new complaint.
Yes, you advised me that the complaint that I had made it
Okay, go ahead.
so that it would be heard. I gave them more than 30 days to get out. I had that complaint to be heard on the same date that they were supposed to either pay or evacuate. And you said, no, I needed to, because my 30-day notice was still good. I refiled on Tuesday, and I received a new case number, and on that summons and complaint, I noted that there is this pending case because they had filed a counterclaim, and you set this hearing for the counterclaim because Mr. Cassidy's attorney.
No.
Okay.
The last time we were here, I was indicating to you what were, as I'm recalling, were distinctions between the notice and the complaint. And basically gave an option that if I dismissed your complaint, what would end up happening is their counter complaint would survive. And so therefore I'd have a case that would just have a counter complaint. So you filed a new complaint.
And I would guess that I would like.
That's fine.
I'm asking for, I asked for the file.
Thank you. You read my mind. Did they open it?
It is open.
Okay. They're bringing it.
Friday.
Got it. Okay. Go ahead.
Okay. So I guess an order of administrative business, would I request now a motion to join that complaint, or do I need to file a motion to join that complaint with the counter complaint?
Well, here's what's going to happen. I'm going to hear them all at the same time, whether I have two files or one file.
Got it.
So you can file a motion for joinder if that's what you wish, but
Okay.
I don't know that necessarily matters. How much are you claiming
Okay.
is owing in rent?
I would like to, I just make a statement. This case is a simple non-payment of rent case based on the agreement to pay rent and utilities for 102 weeks and follow the simple rules stated clearly in the lease and accepted by the defendants. We want $25,891.07 in unpaid rent defendants have been in arrears since September 1st of 2023. That's 9 months. And they
Okay,
have
ma'am,
paid
ma'am,
nothing
ma'am,
since
ma'am.
December 2023.
Counsel, please.
Okay,
So the first thing, I'm just trying to answer some of the things that are raised that are jurisdictional issues that are raised by the defendants to try to clear the way for that.
okay,
All right. And so because I don't have the new complaint, I wanted to know what your claim was.
okay.
And so the dollar amount of
The
it.
dollar amount for the rent owing through May 6th is $25,891.07.
Okay, so let me stop you there.
Okay,
You can either elect to proceed to collect 25,000, or you're going to have, this case is going to have to go elsewhere, which I say won't necessarily make me unhappy. I don't know. I shouldn't have said that.
does that terminate the lease or does that get the lease paid up to now? Because the lease goes for 102.
No. I have jurisdiction at 25,000 on most civil matters. There is some case law that indicates that I can exceed the 25,000 because it's a landlord-tenant matter. But I have to have argument on that in any event. Or what you can do is you can elect to limit your claim to 25,000 and it would stay here. Otherwise, this matter has to be transferred to circuit court.
Okay, so to keep it here before you, that's the first thing, right? To accept.
That I couldn't, you need to understand, I could not issue a judgment or would not issue a judgment
Okay,
for an excess of 25,000.
okay, so we can
Plus
claim
cost.
that, but in order to have it heard by you,
Or
you
in
would
this,
only, yeah. So you're telling us that that's all we're going to get if we
if it
continue.
stays here, that's all that I can do
Okay,
or will do.
okay. Well.
Pardon?
It's not printed or like the paper. JS copy.
There isn't one, but that's all right. I'll be all right.
So,
Ms. Novart, hold on a second. Ms. Novart, is there anything you wanted to say on that $25,000 issue?
Yes, Your Honor. Is it okay if I
Yeah, you can say that. That's fine.
Your Honor, my clients are asking for a $2,000 a month abatement of the rent because of numerous things that were never repaired, that were promised to be repaired. So that almost gets us right there to the $25,000, maybe a little short of that, but our counterclaims will far exceed that. My clients have been retaliated against, they've been falsely accused of harboring illegals, they've been spied on, their property was wrongfully entered by Ms. Toe by numerous occasions. She's called the police on them. She falsely accused my client, partner in a law firm in Houston, of assaulting her. So our counterclaims will far exceed the $25,000 jurisdictional limit.
Okay, so if you attach an affidavit to, actually, you don't have in here, I was trying to make sure I go through everything, but you don't have you didn't file a motion to remove the circuit, did you?
Not yet. We were going to do a motion on the record today, Your Honor. We need to file a motion.
I think there would need to be a written motion with that, with the accompanying affidavits that would be necessary for the court to, because of the way that your counterclaims are stated, there would have to be an affidavit indicating that. Okay. So now here, given that that's going to be their position on the counterclaim, that means well, you guys can't make this easy. So that means the entirety of it would go. All right.
I did have a suggestion.
Well, before you do that, I'm
Okay.
just trying to procedurally think this through. So I'm gonna have to take back what I said, because if it had remained here, I'd just operate with two files and wouldn't care. You would have to file a motion to consolidate this new case with this case. You'll file your motion to remove it so that everything goes. Because otherwise what will happen is, I would imagine that once they file theirs, it will go to circuit. Your case will be remaining here, which I don't know, doesn't make, that wouldn't make much sense to me, quite frankly.
Right.
All right. I would indicate to the parties this, because I don't know why I'm doing this, but what the heck. The other way to go around this would be if the parties were in agreement and wanted sort of a quicker process, is that, and I've done it before in the past, I don't know that I really want to do it here, but I will. And that is that if both parties would agree, I would then talk to the chief judge of the circuit court, have myself appointed as a circuit court judge for the purposes of this case, and have it resolved here, and I could hear all claims. But both parties would have to agree to that before I would do that. It'd be the same process. It's just that, quite frankly, with landlord-tenant cases, no offense to my circuit court colleagues, it's what we do here. So,
yeah.
Your Honor, would the circuit court rules apply in a case like that if you were to hear it? So all the rules of discovery and evidence and the timeline.
the discovery, everything happens as though it's circuit court. So in district court, there would not normally be discovery until the court says there's discovery. In a case like this one, I would have ordered discovery in any event. But what will happen is that you will have those you'd have the discovery and the like.
So if I had gone through this, one of the things that I was going to posit is that if they pay the rent that is owing to date, the lease will stand as it is for 102 days and mediate the remaining issues, which are what she is propositioning, that, there's been wrongdoing on the landlord's side to the tune of $2,000 a month, and then adjust everything once mediation and case evaluation and all that takes place.
Well, I'm certainly not going to speak for Ms. Milber. I'm sure she could speak for herself, but it seems to me that their idea is that they don't know anything, ultimately, right? Or something, but much like.
Depending upon the time frame, there were certain times, at some point, it became owing nothing because of her blatant refusal to do anything. Originally, we were going to ask for an abatement because of major things like air conditioning, central air, which was promised was never fixed. The oven stove isn't working properly. So it may end up to several months, we will ask for no rent at all, but for several of the months, an abatement.
Gotcha.
The home has been not without air conditioning and not without heat.
Well, hold on, because
Well,
I can't.
okay, but you're taking into consideration abatement for things
I'm
that
not taking I haven't taken into consideration anything. I just sat here, hold on. I just sat here and said that I'm just trying to figure out procedurally how you guys are going to hear the case.
I would like to do what you're suggesting. I would like to keep it before you. You know, landlord tenant, you have such experience with it, and that's what this is. This is simply a landlord tenant case.
All right. And Ms. Novar, do you have a position on that? And if you don't, if you want it to go up to circuit, I am not, but by no means will I take any offense whatsoever. I will be more than happy. I will carry the file there myself.
That's where I usually work, so I'm very comfortable in circuit court. However, my client and I would like to discuss it. I think what we'd like to do is wait for the written motion to consolidate the cases, and then we'll have an answer for you then at that point. And we would do, you know, at that point, we will probably do a motion to remove, but we would let you know if we agreed to have you hear that versus.
Okay, and so that you also know, just because this is the other kicker to it, it could get sent up and then come right back.
Yeah.
Because
they know,
just so that you know that that has also happened, where I get the call from the circuit court saying,
I see.
This is
hear this.
Yeah, I understand that a number of our counterclaims are really much more better situated in circuit court, where the judges have had experience with the numerous counterclaims that we have. So,
Well,
I don't know.
I think you should understand that I've heard circuit court cases for 25 years. So I'm just saying, it's more the landlord tenant aspect that isn't there.
right.
But I mean, I am more than happy to send this case up and then let it fall where it may. It's not like I don't have stuff to do.
Here.
Your Honor, may I say something else just in general? We've tried on numerous occasions, including 2 days ago or yesterday, to ask, I asked Ms. Tobin an email, if you like to allow the parties to mediate. Can you order the parties to mediate pending the motions that you're about to hear that will be filed in this case regarding the consolidation and the removal? Because the lease requires it. So I'm hoping the district court, with their somewhat equitable power, little equitable power.
Well, no, we have equitable over landlord tenant. I have full equitable power.
So the lease requires it. We've tried repeatedly to ask for mediation, and we keep hearing no, but the lease requires it, number one, and that could possibly resolve everything.
I would like to speak to that point.
Sure.
Thank you. Our lease does require it through the University of Michigan Mediation Center for Students. Paula Cassidy was a student at the time we signed the lease. They did not go and utilize that term that we welcome in our lease. They went instead to Student Legal Services and had Mr. Lewis represent Paula and appear as her attorney. They absolutely closed the door on mediation.
Can I ask this? Because history is fine, but I don't know that I need it right now. I think what I'm hearing from the defendant side is they would wish for this to be mediated.
Yes, and I am telling you why I have told them no, because they closed the door on that. If we can hear the unpaid rent and utilities, then mediate the rest.
Ma'am, I don't know what happened before.
Right.
Right? All I have is what's in front of me, which is quite frankly a lot. What I'm hearing from Ms. Novar is they would wish the case to be sent to mediation so that the parties mediate. Okay? Regardless of what's happened before, the question then becomes, are you amenable to mediation? I will say also that I can order it to mediation. So, I mean, I typically don't, because I can kind of waddle through what needs to get through, and sometimes you can handle it faster than getting mediators set up. But are you willing to mediate it or no?
We are willing to mediate, but only on the things that they claim should result in abatement. We have rent that has been unpaid. It's caused a hardship for the owners and the landlord.
Okay, so here's the thing. And I guess maybe you should look at it this way. What you have are what are really going to be sort of these firm contractual numbers.
Yes.
Okay. There's, I don't really want to call them soft because I think that's not the way to really look at it. They're going to have numbers when they're talking about abatements and other things, which are the sort of softer side of, and sort of dig into those hard numbers.
Right.
So you can't, it's impossible to separate it out. So there, for example, there would be no way I would take your claims of those hard numbers of, just adding up each month, let that sit there and then send everything else to mediation, because I don't know what then they're mediating against or mediating with. Does that make sense to you?
It makes perfect sense to me, but meanwhile, the owners, landlords have been with the utilities not being paid. We pay the utilities. They have not reimbursed us under the terms of, so, I mean, can we get partial payment and have the abatement amount that they're saying withheld from the payment partial?
How would you, okay,
I'm just trying to get something.
How would you expect me to do that?
I don't know.
Because here's the only thing that I could do. But I could do this, but it doesn't help you. I could order escrow. They could pay into escrow, but it's going to sit here until such time as whatever is resolved and the court orders the escrow split. Now,
our greatest
but hold it. The only exception to that I've made over the years is when something's not paid that jeopardizes the property itself. Then I will order paid out of escrow those funds to preserve
the
property.
Perfect condition.
But other than that,
Period.
I mean, so the bottom line to it is, if the parties want mediation, it all goes or none of it's going to go. Because it doesn't make any sense to do it any other way.
And Your Honor, one of the reasons we want mediation, honestly, is because I feel that, in all due respect to Ms. Tope, that she's been an impediment to settlement. And so I feel if we can get the landlord at the table with the tenants, we have a much better opportunity to settle the case. Not to mention the fact that it is required into the contract that both parties sign. And Ms. Cassidy is still speaking to you about.
Okay. We wrote a really great lease. We had mediation in it. They withheld rent for no given reason. I would, and either party can, under our lease, either party can request mediation at the University of Michigan. If we go to mediation, I will utilize that part of our lease.
If you what?
If we decide, if we agree to go to mediation, I will go to the University of Michigan's mediation that is part of our lease instead of, looking for someone outside to mediate.
Just to clarify, Your Honor, the lease calls for Michigan off-campus housing program to do the mediation.
Is that who you guys want to do the mediation?
I mean, I know a number of good mediators.
I'm not paying a mediator.
If they're limited to, then that's fine. We would agree to do that. We're required, in fact, to do that.
What do you want to do?
Oh, sorry, what was the question?
Well, I'm asking what she wants to do.
I think I just said what we would do. I would agree to mediation. I will go to the University of Michigan. I'm not paying a mediator.
And you're agreeable to that or believe that you may be bound to that.
Yes.
So if that's the case, do we think that the parties can stipulate to an order sending it to mediation?
Yes.
And then in that order, and so you would send both these cases to mediation. The case at this point, and I like Stovar's idea, the case would stay here. Okay. And I just think in the stipulation to send it to mediation that neither party is waiving any right to remove the case. That issue is not being addressed, but it's being sent to mediation. So then you guys can have that fight later down the road.
Could this be folded into a stipulation to consolidate the cases and agree to mediation under the terms that you just said, so we don't have to have separate motions?
Ms. Newmeyer, it really, if she moves to consolidate, are you going to have an objection to the consolidation?
No, we're not gonna.
Okay, so just, why don't you stipulate to,
We did that step first before we did our motion to remove. I was under the impression of,
pardon?
we needed that step done before.
No, you're right. But I think if it's going to go this route, if you can make part of the stipulation that you're consolidating these two cases, send it to mediation, doesn't waive your right regarding the claim removal, and then we move from there.
But we would like a 30-day limitation if possible, that we need in good faith within 30 days. If provided we
What?
can get into the Michigan Housing.
What?
I mean, we're gonna, the case of the
Yes.
language.
Hold on. Okay, what's your objection to what council's proposing?
They haven't paid any rent or utilities, and now we're pushing it on down the road, and we're just.
I think, hold on.
I'm just expressing my frustration. That's.
Well, yeah, and then when I start expressing mine, that's when things get bad.
I know.
So listen, here's
you're
going to be the
patient.
problem. Here's what I heard them say. Okay, so that's interesting. What I heard is almost put it on an expedited track.
Yeah, within 30 days. Yep.
Right. That's, I mean,
I get it.
I mean, I was surprised actually when it was said, because normally for me, if I send it to mediation, I'm not seeing it for a while. And 30 days is maybe too soon. But anyway.
I
So
think
do you have a problem with that?
No, I don't.
I mean,
No, I don't.
and
Thank you for asking.
And here is so could do that. And then here is the other part of it. And I don't really like to interfere with anybody's particular position on their cases. I just, let people argue their cases. But man, I'm going to be frank with you, because and then if it stayed here, there's a jury demand, so I think I can say it anyway. The negotiation in good faith is really going to be clear.
Yeah.
Okay. It needs to be done. Now I'm going to let you know that when you came in here the very first time, and I get parties start yelling at each other about whatever. But you immediately were trying to sort of convince me what bad people the Cassidys are. Yeah, you were.
I only told you that
Oh,
he physically
ma'am,
assaulted me.
ma'am,
Said nothing about the
Ma'am,
personal.
ma'am, I'm going to tell you how the court was taking it then. Maybe I'm all wrong. And what I'd suggest to you is that as you go to this mediation, that you just take that part out and that you try to negotiate the case for what the case is.
Yep.
For all I know, all of you are bad people. I have no idea. All of you are good people, but I assume that everybody is a good person until they show me otherwise. But you also have to listen to what their claims are. You don't have to agree, but you have to listen to it. Now, I'm going to tell you this, man, because when Ms. Novard talks about maybe being an impediment toward trying to resolve it, typically with most cases, where that happens is only where you're looking at your side. It doesn't mean that you don't want to win. It doesn't mean that you don't want to come out. It doesn't mean any of that. But you've got to give some credence to what one side is saying or the other.
That's why we have it in our lease.
Yes, but the parties have to do that, ma'am. And I'm talking specifically to you.
Yep.
Because every time you come in and whatever, when the Cassidys appeared here on their own the first time, whatever he was trying to raise, you didn't even hear it. I didn't ask you to agree. You just didn't even hear it. You didn't even hear what he was saying. And if you don't do that, I mean, they're skilled mediators. I get it, but it's going to be a failure. So, I'm going to hope and I'm going to pray that each side is going to do that as you go into mediation, but I don't know. I mean,
Part of our lease, and in good faith, I follow the lease and I will participate in mediation with everything that is expected of me as a representative of my clients. I know they want that and I will do it.
Mayor, can we also remove the May 31st, the second case, the one that was just filed, set for May 31st, move that from the docket?
Yeah, I'm taking it all off. Once I get that order, everything's coming off my docket. Okay, but I will have to give a control date. And so and that always can be moved. But how long from the time are you looking to have mediation continue? Or what window do you want to kind of give?
I have no idea what
their availability is.
Yeah,
you're right.
But we may pull in another attorney for Paula. We may actually pull in a U of M attorney.
Got it.
That way that may help us.
May help get it there. Okay.
So I'm hoping we can get it within 30 days.
All right, so let's do this. Why don't the parties find out? Let me adjourn this out to the 31st.
Either of us are available.
On the 31st, okay. If people could think they can get everything done in a week, I'm here on the 24th. I'm here every Friday.
We can contact you about housing just in general and see if they can mediate, but
why don't
take a couple weeks to bring you an attorney on place.
Right. Well, why don't I do this? Why don't I set it for next week? Okay.
Yep.
And then you can come back with, and maybe the parties can exchange the stipulation regarding mediation. See where we are. If we run into a hiccup, then I can try to deal with that. And then at least if the call is made, then at least maybe you can have a framework as to, and then we can sort of guide ourselves that way. I think that might be it.
That sounds good. Would you be able to do that appearance by Zoom?
I don't see, if we have the paperwork here, I don't see why not. Okay, if you send it to me before then, everybody can appear via Zoom. What time would that be?
3 o'clock.
All right. So set you for the 24th at 3 o'clock. Okay?
Yes, thank you.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside and this. What is wrong with everybody today? You know what, Miss Green? We're gonna start bringing people in person. People are gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.